Perfect. We are reporting to the cloud. So hello again, formally to everyone. We need to try as much as possible to finish the section tonight on employment discrimination so we can move on with Unit 2. So the area that I'm going to spend and focus the most amount of time on this evening is the ADA, because we absolutely know that we will see questions in that area. I'll happily report that a couple of my students from Group 15 was my most recent group to finish, and they are coming at me hot with positive test results. I haven't had anybody come in yet that they had not passed, so that is so exciting for me as an instructor, and of course I'm thrilled for everybody. So it definitely can happen. Definitely all of you guys can be successful, and so make sure that you pay attention to your study plans, that you're mindful of where you are in HRCP. We were just chatting about that before class started, not to get lost and get behind, because it's definitely really difficult to get caught up. So as far as tutorials, I know that there was a tutorial scheduled today, the differences in the exams. So I don't know if any of you had an opportunity to attend that session, but your next tutorial is scheduled for next week, just to keep in mind that it is on the 23rd on Wednesday, and that is how to apply for the exams. So Jen will look at, she'll literally go to both sites and just guide you through the processes of applying for the exams. I also wanted to, before we start on content, address a question that came up when we were talking about the money back guarantee, and we were talking about the fact that you'll be testing in 2020. And one of you, I'm not sure, I can't remember who it is, doesn't matter, but asked about the materials for 2020. So I did have a chance to go to Jen with that question, because I wanted to make sure that I got the right answer. And the answer is that if there are significant changes to the materials, you'll actually get those sent to you. So you will not get completely new 2020 books, but you will get any updates that will be sent, and you would be responsible for making sure that you are prepared to use those as far as the exam goes. Also, one of the things we chatted about, of course, was the new law that is passing with the update of FMLA, or excuse me, of FLSA, Fair Labor Standards Act, that will be taking place January 1st. And we're going to talk about in depth FLSA when we get to it in Unit 4. So we'll include that in the discussion. So it'll be on the recording and it'll be there. And then as well as the money back guarantee, that SHRM has 2 testing windows. And the testing windows are in the winter and then again in the spring. So anybody that's taking the SHRM exam, if the timing ends up being that between the date that you're supposed to take your exam by our money back guarantee date, so in that case, let me just look at it real quick, it would be April 24th, 2020, the window for you to take your exam under SHRM would have passed. So you won't be exempted from the money back guarantee if your intention is to take a SHRM exam, because with HRCI, of course, you would be able to test anytime. So I just wanted to clarify those couple of things that we had talked about. And then let's see, Lori mentioning, okay, so the Coach's Corner is under the Home tab on the Buzz, or on the Hive rather. And then at the very bottom, scroll to the very bottom, Coach's Corner is the second to the last category. The very last category is tutorials. The second to the last category is Coach's Corner. So I didn't look to see if they had been posted. I don't know if anybody can jump on that and take a look while we're talking. I know that the invitation was there, so There may be some reason she just hasn't posted it yet. I don't know, but that's where they should be, underneath the home button on the Hive page. All right, so let's go ahead and jump into it tonight. We are starting out with the ADEA, which is the Age Discrimination in Employment Act. And we are going to start out with that, and then we're going to get into disability. So let me just jump right back into our chat, just 1 second to wrap this item up, and then we can look at it more at the end of class. So Esmeralda said, I searched for Unit 2 content printout. Are you talking about the slides, Esmeralda, for Unit 2? The ones that we're looking at, like Unit 1? Is that what you're referring to? Those are also located on the Home tab under Resource Corner. If you click on Resource Corner, you will find all of the individual links for the units. You can print either, or download and print either the full page color like we look at right here on the screen, or the ones that has the notes version. So they should all be loaded there. Just keep in mind that, you know, sometimes I do make alterations or changes, but, you know, again, to have it to be prepared with, it certainly is there. And then I'm sure you're seeing that I upload my slides to the site with every class that we take. Also, just popping into my head with notes, sorry. On that note, I did post the summary, but I have not yet had a chance to alter the document that we worked on for the 4/5 rule. So I will be posting that actually under the unit, the summary Unit 2 class that we did is where you're going to find that. I don't want to post it on the Buzz because I want it specifically to be in that lesson. So I should be able to do that in the next few days, definitely before we have class again on Monday. All right, now we'll jump into the ADEA. So this specific law is related to protections of employees 40 years of age and older from, you know, any type of employment action or hiring action. So if you go back to when I talked about the EEOC, and I said we have 2 different types of activities that we look at. One is hiring practices and one is employment practices. The ADEA, although obviously not part of Title VII, still holds true for the same premise. And that's going to be accurate for anything that we look at, whether it's the ADEA, whether it's GINA, which we'll talk about, whether it's the ADA, any of the employment laws are going to really have those 2 buckets of hiring practices and then employment practices. So there are some particular things that you need to be aware of related to the ADEA, and this has to do with retirement programs. And really the main issues with the ADEA came about, I would say, gosh, now it's been maybe 20 years ago, where there was a significant group of leaders that were with organizations, particularly in the automotive industry. And I think GE was one of the companies at the time that all got pushed into retirement programs before they were necessarily ready. So they were involuntary, basically, retirement programs. And so ADEA got really hot during that time because certain individuals that were affected went back and said, hey, you can't make us retire just because we've been with the company a long time if we still want to continue to work. So with that came additional guidelines, and then came the Older Workers Benefit Protection Act that has to do with making sure that retirement programs that are offered to employees are correct and they're not discriminatory alongside the ADEA. So in the event early retirement programs are offered and put in place, we just want to make sure that they have the guidelines that are listed on our screen, that they're fair, essentially, to everyone involved, that they are, that last bullet point is important, that they are knowing and voluntary, meaning that this offer is made to individuals who fall into the job class that is deemed the class by the employer, irrespective to age, because you could have someone who started working somewhere when they were 16, as an example. One of the best examples where I live is the grocery store Publix that I talked about, where Publix, you know, you can start working at 14 years old at Publix. So in 30 years, you could be, you know, still in your prime as far as career goes and retire from Publix in your 30s with all of that time period. So early retirement programs, you know, making sure that they're irrespective to the age of the person and that they obviously fit into the confines of the ADA, or at least make the consideration of it. So when we look at the additional parts of the ADEA, and you go and look at early retirement programs on page 30 and 31, I want to point out a couple of really important things that is in addition to what's on our slide. So the first one is that the treatment in the retirement offerings has to be better, not worse, meaning that it can't be something that is viewed as a punishment. It has to be something that me going ahead and taking this will benefit me. It won't take anything away. So if the employee would get X amount at 30 years of employment and they're offering an early program, it has to be subject on them not missing what they would get if they were to stay. And that was a big part of what those companies did wrong when they did all these massive early layoffs back, I think it was about 20 years ago now. Then when we look at page 31, under employee acceptance, a really important component of that is number 6 and number 7. And these are definitely 2 items that show up on the exams. In fact, I had about an hour-long conversation last night with one of my students that just passed yesterday, her PHR. And we were talking about all kinds of things, you know, what was on the test, what she saw, what she was surprised at, all of the same information that was, it was great to talk to her because it just cemented that what I continue to teach and we continue to cover in the course is right on target for people taking their exams. So that always makes me feel really good to have that confidence that we're, you know, definitely doing things in the right direction. And so item number 6 and number 7 came up in some test questions that I was looking at today, actually preparing for the SP and SCP, because there are not a lot of, there's no free resources out there yet for the SHRM exams, but I've been previewing and working on some Amazon resources that are not that expensive, but would be beneficial because, Amazon questions, SHRM questions are all situational judgment questions. So they are very different than the HRCI exams. So anyway, when we look at item number 6 and item number 7, this has to do with severance agreements. So any type of agreement that you offer an employee, and honestly, this is whether or not it's early retirement has nothing to do with it. It's whenever you're making a severance agreement to individuals that either as a group are over 40 or individually the person is over 40, then you want to follow the guidelines that are listed here. And so number 6 is important because it provides some date-based compliance, which means that you read number 6, it says the person must be given at least 21 days to consider whether to sign the agreement, or 45 if the release is for a group termination, and they must be allowed to revoke the release up to 7 days after signing it. So there's a couple of important pieces here. Number 1, it is the amount of time the person has to have to be able to what we call consider, that's in air quotes, consider the agreement. So that means when you give the agreement to them, then they can take the agreement. They need to be advised that they have a right to consult an attorney, which is number 5. And so they have technically up till 45 days if it is a group of people being affected. Regardless of the age makeup of the group, you always want to look at that as far as group terminations go. And then after they sign the agreement, they have 7 days to revoke their signature. So when I sit down with either an individual or a group of individuals about a reduction in force, about a separation maybe based on performance where we're actually involuntarily letting the person go, I always include a copy of our payroll calendar so that the employee understands that the date of payday is not the date where they need to have it back, that we've got, in most companies, let's say you're on a biweekly payroll, you have a date of which payroll is due, and payroll is being processed then after it's been approved, and then usually your pay date is about a week after. And so it's important that people understand that process, and taking the time to explain it in the beginning to them, believe me, will help you tremendously, because then your phone is not ringing off the hook or your email pinging with people saying, okay, I'm going to send it back to you. Am I going to get paid on Friday? Well, no, it doesn't work like that. So you need to make sure that they understand whatever, either the 21 days or the 45 days, and then that they have to wait 7 days. And in some cases, of course, that 7 days may cross the due date of that particular pay period. So it's really important to make sure that employees understand that, and that you're not setting up a wrong expectation of how they're going to get paid. Another thing to make sure that you're aware of is, how is the payment going to be made? And that's not part of the law, but just from an employee relations perspective, is the payout going to be in one lump sum? Is the payout going to be over the number of pay periods? Let's say that they get 5, we'll say 6 weeks worth of pay. Essentially, that would be 3 pay periods. And so how is that going to be paid out? So communicating that to the employee in advance, when, especially if they don't know that it's coming, can really help. You'll still have questions because of the shock of, you know, somebody getting let go or somebody getting laid off, but it can help prevent a lot of problems. And then number 7, if the release is for a group of employees, then you are required to, with their severance agreement and severance information, you are required to present to them a list of all of the people in the group affected, as well as the job titles and ages of people selected for and excluded from the program, from the layoff, whatever it happens to be, reduction in force. So that's a really important piece that is required, that if anybody were going to go to a lawyer and inquire about their rights, that's one of the things that the lawyer is going to ask for, of wanting to see who was included in the group that was actually affected as well, and then you who was not in the group. And so that's something that attorneys will be looking for. All right, there's a question that came in here. Are you saying that you shouldn't put severance with someone's last check? I missed the first part of what you were saying about payroll and paying severance. The only time that you should ever, if you're actually providing a severance agreement that is going along with that money. So when you provide a severance and create a severance agreement, the consideration, that's a legal term, the consideration that someone takes for signing the agreement and signing away their rights of being able to file claims under anything and everything under the sun, they get paid money. So the money is the consideration. So you always want to make sure that even someone that's under the age of 40 has 7 days to consider the agreement and 7 days to execute the agreement once they have given it back, because they have a 7-day legal ability to revoke the agreement. So you can present the agreement to them, and you'll have a lot of situations where employees will say, I don't care about the 21 days and the 45 days or even about the 7 days. I just want my money, and they'll sign it right then and there. That's fine, but you have to make sure that you advise them that they have those amount of days that are under the law, and that then once they sign it, you can't just pay it out. Like if let's say that you terminate them on Wednesday and your payday is in 2 days from now on Friday, you can't pay them out on that Friday because the agreement requires a 7-day revocation period. So you would have to pay them out on the following pay period. Does that make sense? Jessica's saying 40 and over have the revocation period, but below 42. So legally, under 40, you're not required to give that 21-day or that 45-day. Those are legal requirements based on the age of the employee under the ADEA and the Older Workers Benefit Protection Act. But if you're giving someone severance, it has to have that minimum of 7 and 7 in it. That's a legal part that's built into a severance agreement because of the consideration of money that you're giving. And they have to have the right to consult an attorney. Because essentially, when you present that severance agreement to them, you're asking them to give away their rights, to sign away their rights in consideration for giving them money in return. So they have to be able to have those days legally. Like if you were to just give them an agreement and the 7 and 7 wasn't written in there, and then you paid it out, they could easily go back to an attorney and say that it was a wrongful termination, that they didn't follow the process. So a lot of times, here's an example. If I'm doing a one-off on someone that's 30 years old and it's for performance, and we're going to pay them severance because we just decided that that was the right thing to do in this particular situation, I'm going to give them a 7, and we call them 7 and 7s or 21 and 7s, a 7 and 7 agreement. But if that individual is over 40 and it's not a group termination, then you're going to do a 21 and 7 agreement. If it is a group, then you have to do a 45-day agreement if the group contains individuals that are above the age of 40. Let's see. So Maureen said below 40, they also have 7 days to revoke. Right. Well, and it depends on what your company does. For example, when I worked for the medical device company, we had a very frustrating policy, internal policy, that anyone who was exempt that was terminated, not someone that voluntarily quit, but terminated for any reason, whether it be performance, attendance, breaking a rule, gross misconduct, anything, that they automatically got severance. Automatically, no questions asked. And the reason that they did that was to avoid lawsuits and claims. So from their perspective, the money that they were going to spend on the front end and the amount of severance that the employee would receive was well worth the costs and the headaches and the potential money that we would have to deal with on the back end if that employee went and made a claim. So giving them money to sign their rights away was their preferred way to do things. It was very frustrating sometimes, especially in cases where somebody harassed someone or, what else, and they, shouldn't get any money for their conduct, but that's just the way it was. So in those one-off situations, my agreement is either going to be a 7-day agreement if they're under 40 or a 21-day agreement if they're over 40. Now, the 7 and the 21 and the 45 are, again, based on the type of agreement, and you legally have to give them that time. You have to tell them that you are advising them that they have this much time to consider, decide whether or not they want to sign the agreement. If they don't want to take that time and they just want to sign it that day, that's okay. They can waive their right to that time. But once they sign it, there's a 7-day revocation period. So let's say they sign it. They go home that night. Their spouse who's in HR says, oh my God, you should have never signed that. You need to send that. And, we need to go talk to an attorney, blah, 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 blah. So now they're in that 7-day revocation period. And at that point, then they can call up the company and say, hey, I know I signed this agreement, but I am in my revocation period and I decided I don't want to do that. And so then at that point, they have a right to then go do whatever they want to do. If they're still in their consideration period, then they have the balance of how many ever days is still available for them to decide whether or not they want it. But if they were to sign it, let's say on day 45 and then revoke, well, now they're out of luck because their consideration period is now gone. I know there was some questions kind of going in. Laura mentioning the payout for severance. Yes, that is 100%. I think a couple people are responding, so thank you. Yeah, we determine our own payout. So in some cases, a couple people said, let's see, Christina said, number of months of severance is based on their tenure. That's generally how most companies do it. It's 1 week per month, typically, of employment, or year rather, 1 week per year of employment. So we can determine whatever we want to give, but obviously in a group situation, you've got to make sure that everybody is, whatever method you're using, that it's consistent. So if you are using your hire date or your anniversary date, that you're using that same date to calculate everyone's allotment of severance. So, all right, good questions. And then let's see, anything else on that? Anybody else have any questions? Okay, so the next thing that is there's not a slide for, but it goes along with the next slide, is age and age harassment. So age harassment is at the bottom of page 31, and it's important to include age in all of your equal employment opportunity training, policies, documents related to anything on harassment, such as people making comments about someone's age, even if it is meant in the sweetest way. Okay, and I know I sound very naysayerly, if that's a word I just made up, when I say this, but I'll give you the best piece of advice I can regarding employee relations, which is it's never a problem until it is. And basically what that means is that if you're in a situation where you've got, let's say, an older person, and you refer to that person as Pops and Grandpa, and, the guy from yesteryear, whatever phrases and words that you use that are in the company and they sound endearing and they're most likely meant in not a negative way, those types of phrases will come back and bite you in the behind when then you fire that person and they go and file an EEOC charge against you for age. Because they're going to say that all of these expressions were used that created this environment that differentiated them by age. Because you're not talking to a 30-year-old, and you're not, necessarily calling that person expressions that may have to do with their age. So that's what I said, the expression of it's never a problem till it is. Because I've even had situations where I overheard these terms being used, and again, terms of endearment, nothing mischievous or negative meant. And I've actually gone to the employee and said, hey, I heard that these couple of words were, being used for you. And they're like, oh yeah, it's okay, it's not a problem. And I'm like, well, yeah, actually it is. Because using that language is differentiating that person on a particular characteristic that is prohibited and protected by law. So just make sure that your managers, your employees, that you include age with your EEO statements and your training, because it absolutely can be something that can come back. And really hurt the organization from a claim perspective. And then when they interview your employees, the EEOC interviews your employees, or the lawyer interviews your employees, the employees are all going to say, yeah, that person was called that. And then HR, if they know, is complicit. The manager who managed the person was complicit, and maybe he even called the person that. So it reminds me of a case that I had in rural Georgia when I was managing the automotive company, and a young girl who was just probably 20 ended up going to the EEOC and filing a sexual harassment claim based on her gender. And I didn't know about it, so I got the claim. I didn't know that there were even any complaints. I mean, of course, after the fact, I talked to her about it and said, hey, I wish that you would have come to me. We could have dealt with this. I mean, they have a right to go to an agency. That's fine. We dealt with it. But in this situation, the manager, who was extremely Southern, was raised, good Southern boy, if you will, constantly called her pet names: baby, sugar, darling, honey, sweetie pie. And she asked him repeatedly to stop. And she told him, hey, my name is, Christy, let's say, and I would prefer that you called me by my first name. Please stop calling me those names. And yet he persisted. And she told him 3 or 4 times. There were lots of witnesses that said, yeah, she told him 3 or 4 times to stop doing that. And so by the time it got to me, it had gone on for a year at that point, and he still continued to do it. And so when I sat down with him, with the manager, I said, so tell me why you did that. And he's like, I didn't mean anything by it, Melissa. That's just what us, good Southern boys do. And it's not meant of any harm. And I was, and I said, well, did she ask you to stop? Well, yeah, but I didn't really think that, it was really bothering her. And I'm like, how many times did she ask you to stop? Well, a few. So maybe I guess I should have. And I said, let me ask you this question. And he said, yeah. And I said, do you call the guys honey, sweetie, darling? I said, do you say those same expressions to the men of the male gender that work here? And he's like, well, no, of course I don't, And then he made some offlandish, gay comment. I don't want them to think I'm gay. And I'm like, but that's exactly the point. You're specifically using words that are designated to her as a female gender, yet you're not referring to guys that way with any particular sweet pet names, right? And he's like, yeah, I guess. And I mean, he got fired. But that's a great example of the same thing as age. where it can come back. And I tell people, if you're, I am saying this kiddingly, of course, but if you're going to harass, be an equal opportunity harasser. You know, be a jerk to both sides of gender or race or whatever. So at least we have, you know, some sort of half a defense to be able to say, yeah, well, he is a jerk, but he's a jerk to everybody. And he says, he calls everybody names. So, you know, at least you've got something to try to defend. But obviously I'm kidding on that. But I have told managers that before, but certainly don't want them to do that. But that's just a really good example of a situation and it coming around and biting you in the backside, if you will. All right, so the last slide related to age has to do with BFOQs. And you'll remember that BFOQs are legitimate discriminatory measures that we could use to defend why we took action on someone based on a particular age. So age-related BFOQs would be, for example, not hiring someone for an acting job that needs to portray a character that is of a certain age, or a model or anything like that that you could justify for business necessity. If the person is released for good cause, so if it's a gross misconduct issue, if they're terminated for performance, of course, those would be justifiable regardless of the age of the person. Anytime you have a seniority system, which are typical in unionized environments where your seniority is going to be based on your actions, are going to be based on seniority. So let's say you have a policy, part of your union agreement that says in the event of a layoff, it's the last person hired approach, which is very common in union organizations. So in that case, if the last person hired happened to be over 40, and that's what's written in the agreement, then that would be a BFOQ because that's how the agreement is written. So that is the couple things most important related to age, and then the ADEA. And then we move into our first knowledge check question of the evening, which says, an employer who requires older workers to perform difficult, degrading, or boring jobs in order to get them to quit may be found guilty of A, dissuasive practices, B, negligent management, C, tolling, D, constructive discharge. All right, so the answer here is D, constructive discharge. We had some kind of D's and A's. I'm going to tell you my opinion about this particular question, and I feel very strongly about this. Constructive discharge will come back up in Unit 5. Please do not connect constructive discharge only to older workers. Constructive discharge is applicable to anyone as a claim that an employee could make about the work environment. And the main important parts that are in constructive discharge claims are at the bottom of page 31 under where it talks about constructive discharge. And the primary things are that the environment has to be so intolerable that the person feels like they have no other choice but to resign. And constructive discharge cases are very difficult to prove because the action of the employer has to be what the law considers, here's my air quotes again, severe and persuasive. And it has to be severe and persuasive enough to have someone from the outside, like a juror, basically look at what the employee claims that they were subjected to and say, wow, that was really terrible. That was awful. and they did those things in order to get the person to quit. They're very hard claims to get from the person making the claim. But I don't like the way that the book connects them in this way, and they do it again in Unit 5, where the knowledge check question, giving you a preview, has to do with older workers. So just please keep that in mind, because I don't want you to see a question on the exam, and also for your real life HR experience, that connects the two. Could it be an older worker? Yes, of course, but it could also be a 20-year-old. So just make sure that you're not making that connection. All right, now we're going to move into disability discrimination. Our first one is vocational rehab, which came out in the 70s. That was important because it was the first piece of legislation that really focused on individuals that had issues that related to discrimination with a, quote, handicap, which is at the bottom of page 32. When we look at vocational rehab, it's applying to government contractors and subcontractors greater than $10,000. It also requires, as you see on the slide, affirmative action for hiring and promoting disabled. And then at the bottom, that last bullet point is really important. Does not apply to those who abuse illegal drugs or alcohol. And I'm calling that out because, as we're going to see in the ADA, the Americans with Disabilities Act, treats that a little differently. So just keep that in mind, because there are questions that you might see where they're specifically related to the Vocational Rehab Act that talk about alcohol, illegal alcohol and drugs. All right, so then the next one is the Vietnam era VRAA, and this has to specifically do with disabled veterans. And so you'll see the enforcements here by the OFCCP, requires affirmative action. So one of the things you need to connect in your mind is that anything with a federal contract or subcontract is going to require affirmative action. So if you see a question on the exam and you see those acts and they talk about issues related to federal contractors, you always want to, make sure that when you're looking for the answers, that your answer should contain something related to affirmative action plans. Of course, if that's what the question is about, because those are all tied. Any government contracts are going to be tied to the required AAPs. Okay, now we get into the ADA, which is a big thing that is within our HR community that we're responsible for as practitioners, as well as an important component of Unit 2 and of the exam. So I want to take a quick poll here just to say, on a scale of 1 to 10, where would you rate your understanding and applicability and experience related to the ADA? So 1 is, I know it, I'm familiar with it, a little bit, I don't really have a lot of experience. And then, of course, 10 would be, I'm an expert. All right, and while those numbers are coming up, let's see, Christy, I saw a question fly by. Christy, there is never a stupid question, of course. Why are there so many disability laws targeting government contracts? Just to ensure that obviously our government, in its roots, in its origins, stood for equality for everyone. And so anybody that's doing business with the government, with the United States, the government wants to make sure that that same principle is applied to people that are going to be employed in those contracts. So that's the primary reason. And, you know, you would think that it would be a given, but the laws are there. Like anything else, you know, when we are at our companies and we have to create a policy for something, a lot of times it's because somebody's done something that wasn't great, and now we've got to come up with a policy about it to protect the organization. So it's obviously at a very different level, but just to ensure that people are doing the right thing and that they are making those jobs equally available to everyone. All right, so I'm scanning the ones here, and we've got a pretty good amount of people who have higher numbers. Let's see, Renisha's got an 8. Give me the set an 8, 9, or 10 gets to teach this. Did I tell you that part? You can definitely add in anything that you think that I may be missing, for sure. This is an important law for us, again, as practitioners, as well as the exam. The thing is, related to the exam, there's a lot of pieces and parts that they can come at you with. So that's the way that we're going to have the discussion tonight on this. So let's start out talking about the ADA in its concept. So obviously, I'm sure everybody knows that it is related to protecting individuals from discrimination related to their disability. So the first thing that we have to look at is what's the definition of disability, which is about halfway down page 34. So number 1, physical or mental impairment that substantially limits one or more major life activities. Number 2, has a record of such impairment. Or number 3, is regarded as having such as an impairment, such as being a former drug addict or alcoholic. So we're going to talk specifically in a few minutes about that drug alcohol piece. So just keep that in the back of your mind for right now. But let's look at really number 1 and number 2 and how they go together. So number 2 is from the perspective of having a record of such an impairment. So someone that, let's say, had cancer, breast cancer as an example, went through treatment. While they were going through treatment, they may have had the issues that would have affected one or more major life activities. They're now in the cured stage of, you know, being cancer free. But they are still going to be regarded as someone that has had a condition that created and made them disabled. Could have made them disabled, not necessarily, because there's plenty of people who have cancer and still, you know, go to work every day and use intermittent FMLA for their treatments, and still potentially might even have to have some accommodations. So in 2008, the ADA was amended, and it is now technically called the ADAAA, but I don't know if anybody that uses that term, we still just call it the ADA. But it made a huge change for employers by adding a significant amount of conditions that were now under the guise of that definition of impairment that limits one or more major life activities. And so the some of the ones that were added are at the second paragraph, or technically it's the first paragraph on page 35 that were added. Also on, let's see, yeah, the paragraph after that, easily be concluded to be covered under the ADA. Things that are going to be apparent when you see someone, such as a person being in a wheelchair. The thing is, however, you can't make the assumption that someone who's in a wheelchair automatically is going to need an accommodation for the work that they're interviewing to do. So the ADA is another one of those laws where it has 2 sets of implications. One is in hiring practices, and one is in employment practices. So we're going to talk about the employment side right now, and then the last part of the discussion, we'll talk about it as it relates to hiring. So when we talk about the major life activities and the conditions that are now covered by the ADA, things that weren't as easily added in and identified as before were a whole slew of categories on the psychiatric side, such as anxiety and depression, as an example, PTSD as another example. Certainly ones that had probably already been there, such as schizophrenia, but there's been a lot of additional views and cases that have come up regarding psychiatric types of ailments, another one being ADHD as an example, or ADD. So you got to be really careful related to the ADA, because you can't make the assumption that if you can't see it, it's not a condition that would be covered. So when you see a person in a wheelchair, there's an automatic bias that happens that that person is going to be viewed as disabled and therefore would need an accommodation, which again may not be the truth. The other thing that was amended, which is issues related to mitigating factors, which means that, let's say someone that is diabetic and when they start working for your organization, their diabetes is controlled. And then as they go along, something happens and they now need insulin. And so they have to be able to have specific times that they need to take insulin, or whatever that case may be. And now it may be that some accommodations need to be made, and they go along for a while and they get better, they get their blood sugar under control, and they no longer need those accommodations. So they are still in that category of having a medical condition that is covered under the ADA, whether they need or do not need accommodations. So one of the most important pieces, especially as it relates to accommodations, is the interactive dialogue and interactive conversation. And I'll pause that for 1 second because we're going to get there in just a minute. So I specifically want to address the issues with drugs and alcohol. Let me look, there's a couple chat things here. Oh, someone made a message to me, migraines as another condition. Absolutely. The things that can happen that are potentially intermittent can still be considered disabling illnesses or injuries, or whatever category it is under the ADA. So migraines is a good example for the fact that they don't happen all the time. They're not every day, all day. If you're, in a really difficult spot with them, they might be, but someone that takes medication still with that medication may not be able to function. It might just, take the edge off to the point that they're not, vomiting or have to be in a dark room, or, whatever the case happens to be. So that mitigating devices piece is really important, because even though they're taking a medication or using something that helps get them better, doesn't necessarily no longer mean that they are protected under the ADA. Specifically, whoops, there's one more question here. Emily asking why the 15-person threshold. I agree with you on that. This is solely my opinion. I think because under that number up to 14, in a small business like that, based on the accommodations that employers may have to make, they may just not be able to handle that as a business. If you're in a small company like that and your employee rather needs let's say it's a pretty heavy type of accommodation, whether it's time or a modification that needs to be done in the work environment, that you may not be able to afford to do that because you're such a small company. So that's my opinion. I'd have to look up the regs to find out the actual meaning legitimately, but that would be my thought. Okay, so let's look at the issue related to drugs and alcohol. So the book is actually, this is super interesting to me, and I've actually gone to the publisher about this issue because I feel crazy passionate about it, that it's actually misprinted in this section. When we specifically look at page 35, the second paragraph from the bottom, which says current use of alcohol or illegal drugs is specifically excluded from coverage. That is not an accurate statement. So I'm going to break it down for you to show you what is and isn't. And then interestingly enough, in Unit 5, when drugs and alcohol are discussed again, they say it correctly. So I don't know if it's just a misprint, if it's a mistype. I don't really know, but I just know that I have an obligation as you're reading material to make sure that you get the correct information. Let's talk about drugs and alcohol, because it is a specific area that it's, especially on the drug side, it's an epidemic in our country. On the alcohol side, let's talk about that first, because that's a little more cut and dry, I guess, if you will. So someone that's an alcoholic can have problems being able to perform their job. So just being the virtue of an alcoholic does not mean that they automatically get special treatment under the ADA. The ADA is about making reasonable accommodations for conditions that meet the definition of disability. Alcohol and alcoholism is one of those conditions. Doesn't mean that you can't discipline your employee for having performance problems, like any other type of issue. It doesn't mean that they're automatically protected, anybody with a disabling issue, from performance issues, from violating any other policy that you might have. Most of us, I would say probably all of us, have policies in our handbooks that say you're not allowed to drink and use drugs or be impaired while you're at work. So someone that comes to work that is impaired and drunk, or drinks during the day, or you get a anonymous tip that so-and-so has alcohol in their drawer and they're spiking their coffee with vodka, that does not mean that you as an employer don't have the right to address that issue as a policy violation. Okay, so that's where we got to make the separation. Now, if you're in a situation where you're meeting with an employee and you're discussing their performance issues and they say that they're an alcoholic and they're having problems right now, then as an employer, you have to start the discussion of talking interactively with them about what could you possibly do to make a reasonable accommodation to help them with their alcoholism as a medical condition. It might mean that they need to take a leave of absence and they need to go on FMLA and they need to go into treatment, and your health insurance covers that treatment. It may mean that they that they recognize that there's an issue, that they're getting back into AA, and they need to have an hour off every Thursday, let's say, or every Tuesday and Thursday to get to the meeting that starts at this particular time. That would be an example of reasonable accommodation. So it doesn't mean that you have to say, oh, okay, well, you're an alcoholic, so you're exempted from the same standards that everyone else is in the organization, or that you're exempted from following our policies about being an alcohol and drug-free workplace. Doesn't mean that at all. It just means that you're required to discuss with them the topic of the condition, of the interactive discussion, and potentially what might be a reasonable accommodation. So that's the first side, that's alcohol. On the drug side, we have to separate it into prescription drugs and illegal drugs. So prescription drugs is the same issue as alcohol is. If the issue, if they're taking too many, if it's affecting their performance, if you're at work and you notice that they are impaired, obviously one of the first things that you need to do in alcohol and drug situations is maintain and make sure that the person, your employee, as well as the work environment is safe. And so if they're impaired and they come to work impaired, you certainly do not want to send them home driving if they're impaired. The other issue that can happen is there are medical conditions that can mimic someone being impaired. Diabetes is one of them. So someone that has their blood sugar go too low and they become hypoglycemic can slur their speech. They can sound confused. They may not be able to walk well. Their gait might be off. They can become combative and, I've had situations where an employee in the break room, I got a call, was throwing chairs everywhere. I mean, they thought that this person was psychotic. And, everybody was really freaked out. And so we got the, break room cleared. We called 911. The person fortunately had a bracelet on that said that they were diabetic. And the person's blood sugar was like in the 30s. And he basically was passing out, but he was really agitated while his blood sugar was decreasing more and more by the minute. So you can't make assumptions about what's wrong with the individual totally based on their actions or based on how it presents. So it's really important to make sure that your managers know that, because I've had plenty of managers say, Melissa, I think this person's coming to work drunk, or during the course of the day, I think they're drunk. I think they got drunk at lunch. Well, and that very well may be true, but you can't necessarily confirm that. You also have to be really careful in particular states, because marijuana, which Christy mentioned, we're going to talk about in just a minute, marijuana is still federally against the law. So in particular states where certain drugs may be permissible, then you obviously have to create your policies and work environment around that. So we'll talk about marijuana in just a minute. And then the third category is illegal drugs. And so as it relates to the ADA, no illegal drugs are covered, which includes marijuana, because it is federally not legalized. So when you talk about the ADA and you talk about accommodations and protections, now that doesn't mean that you wouldn't want to afford the same opportunities for addiction services to someone addicted to illegal drugs as you would someone who is an alcoholic, meaning you bring them in, you're talking to them about their performance, and they disclose that they have a drug problem, then you would still want to offer those services under your plan through EAP or through your psych benefits, because drug abuse is also an addiction. But the difference is that illegal drugs do not require an accommodation, where alcoholism and addiction to prescription drugs, i.e., let's say Xanax or Percocet, that your employee is legally being prescribed but still becomes addicted to, that would be in the same classification as alcoholism, as far as going to a meeting or taking time off or whatever, you know, those potential accommodations are. But it doesn't mean that you can't discipline your employees just like you would discipline anyone else on the drug and alcohol side. Then if they are finished with treatment and they're back at work, then they are on the illegal side regarded. They fall into that regarded category or a record category, regarded as being a former drug addict or alcoholic. Although, you know, I think most of us know that once you're an addict, you're an addict. And even if you're in a recovered status, most people would still consider themselves an addict, but they just, instead of being active, they're recovered or in recovery. So let's talk a little bit about marijuana, and then I need to move on and we can continue the discussion after class if you'd like to. With marijuana, if you do research on it right now, what you'll find is that organizations are modifying their policies as it regards a couple of different things. Number one, recruiting. And so a lot of employers in states that have marijuana approved, whether it's medicinal or recreational, are having to make the decision about, okay, what do we want to do relative to our hiring practices? Do we still want to have a no drugs at all policy as far as hiring, or do we want to say it's applicable to certain classes? Like, for example, someone who drives a vehicle, you should not be hiring someone that tests positive for marijuana that is going to be driving a vehicle for your company. And most likely, your automotive insurance carrier is still going to require you to maintain coverage of excluding those individuals from being hired. So the fact that it is legal in the state, the company is going to have to decide how they want to deal with that. Insurance companies are still looking to employers to have drug-free workplaces, meaning that if someone is busted smoking marijuana during a lunch break, that, or they come back impaired to work, that violates the company's drug and alcohol policy. So it just really is subject to individual company interpretation. But from a testing perspective, I mean, as in the exam, the prep class exam, it is still not federally protected. So you just have to be, you know, to make that distinction. Now in California, I'm sure, just as an example, Colorado, there are probably plenty of organizations. I don't know if we have anybody in those that can speak to it, but from, you know, I keep track of this topic particularly because in Florida, we are medicinal, but it's on our next ballot for recreation. And so it will significantly change a lot of things. And even in the town that I live in, they just passed legislation that you're allowed to have, you know, up to a certain amount on your possession. If you get pulled over, you get stopped, whatever, before it's actionable. Like you can get arrested for it. You can have a certain amount on you. So I think as, you know, different states continue to experience this, they'll have to adapt to whatever makes sense for their organization. You know, if it's a call center and nobody's on the road and nobody's getting hurt and, you know, nobody has the potential to get hurt from a safety perspective, they may be more likely to do pre-employment drug tests, but exclude marijuana from those tests. So they're still going to test for cocaine and meth and ecstasy and everything else, but they're going to exclude marijuana because the people, you know, the challenge, the balance is finding talent, which is where companies are having the biggest problems in states that have recreational approved. Yeah, Brandy. So this is perfect. Brandy saying DOT drivers. Yeah, you can't have somebody as a DOT driver under federal law that has any drug issues. So that's a perfect example of what happens in a state that has recreational or medicinal approved. All right, so let me just look at Christy's comment here. Throws everything all over. Yeah, and it also, you know, goes back to my point about individual companies making those decisions. And then for, you know, workers' comp, most workers' comp companies are going to still require you to be a drug-free workforce. Maureen mentioning heroin addicts receiving methadone treatments under treatment, now using a legal drug, which comes up as positive with proof provided. This would be covered under the ADA. So if they're in a status of actively in a program and they ask for an accommodation for that program, then yes, I would cover it under the ADA. I would have a discussion about it. And you have to think about, which brings us right into the discussion of reasonable accommodations, is, you know, what is reasonable for one company isn't necessarily reasonable for another company. And so an employee asking for an hour off to go get their methadone treatment is because they only do them between 9 and 12, 3 days a week, and that's their work time. Well, that's a reasonable accommodation. And then you'll have to make the decision internally if you want to make them take that unpaid, or if they can use PTO time for that time, or if they can make the time up, like by staying an hour over. I mean, those are all internal decisions that the company would need to make. The thing there, though, is consistency. So if you're going to do it for one and how you're going to do it, then obviously you need to be consistent in making those decisions. Let's see, Peggy, or let's see, Laura said we test all employees even if they are not DOT, because yeah, federal contracts, again, going back to that federal government component where it's not protected yet. I mean, I think we'll get there eventually, but that's a long ways away. So right now, you know, it's going to be state by state and company by company. Peggy saying, would the employee have to ask for the accommodation before they were tested? Do you mean pre-employment testing, or do you mean like reasonable suspicion testing? Because under pre-employment, which we'll talk about in just a minute, under pre-employment, you generally wait until the test result comes back, and then the medical review officer will call the candidate and tell them, ask them, because there are things that are prescription. For example, benzodiazepines is the drug category that Ativan and Xanax fall into. And that's can be a street drug that people can go buy, but it's also a legitimate prescription drug that somebody may be taking for an anxiety disorder. And so once the MRO calls and you test, because you've tested positive for that drug, then you're going to prove to the MRO that you have a prescription for it, and then they're going to report your result as negative because you validated that you have a prescription medication for that drug, and then they'll report the test back as valid. And sometimes, you know, if you're looking at your drug screens regularly, you might get a notification that there's what's called a presumptive positive result, and then that might disappear after the MRO has an opportunity to talk to the candidate. And in my experience, generally those will end up being because there's a legitimate prescription for them. Let's see. Oh, Peggy said, oh, the heroin comment. Well, would they have to ask for the accommodation before they were tested? Well, with, on the heroin side of things, the methadone is a medication that people who are addicted take as they're getting off of the heroin because of all of the terrible side effects that go along with heroin withdrawal. So they would probably be doing that through some sort of rehab program. And if they needed the time off for the accommodation, then obviously they're going to have a discussion with the employer about that. Laura mentioning, when we provide the offer, we provide policies on drugs and alcohol and all the types of drugs. Yeah, I mean, I agree. Put it out there. We didn't necessarily provide the list of what we test for, but I certainly would discuss it with somebody if they asked. If it's a 5-panel, a 7-panel, what does it consist of? Is it, saliva, urine, hair? What are we looking for? All those kinds of things. And Sam's saying, we're a Colorado company with a huge presence in DC. Our parent company doesn't drug screen new hires, but it's a requirement for federal subsidiary because they work on federal contracts. Yeah, that's another great example of a situation where the company has had to make modifications based on certain elements of the business. So when we talk about reasonable accommodations, and I do want to finish the section. I know we're at the top of our time now, and I fully anticipated that this would happen. So if we'll finish the section on ADA, and then just to give everybody a chance if you do need to get off the session. So we'll finish ADA tonight. When we come back on Monday, we're going to finish this section, and then please, it'll only take a little bit, and then be prepared to go through section 2.2, which is on human resources planning, and then also potentially to get into the part of 2.3. I don't know for sure that we will, but I would say just to be prepared, which is pages 77 through 86. It's a pretty short section. All right, so back to the disability discussion. I also want to mention, before we go to reasonable accommodations, the direct threat component, because that's another area that's on page 36 that also comes up on the exams. So if someone is a direct threat, it can be from a number of perspectives. It can be from the perspective of pre-employment based on their disability. It can also be after the employee has already been hired based on something that happens in their condition. And the best example that I can give you, the diabetic example is a good one, where because the employee was throwing chairs, they were combative, obviously the safety of our employees is going to be of paramount importance, along with the safety of the employee as much as we obviously can without someone else getting hurt. So in that situation, it would be a direct threat element. You might also have direct threat situations where someone, for example, that has schizophrenia. For the most part, people with schizophrenia are not combative. It's kind of a common misconception if they're medicated and if they're on their medication. When they're not medicated and they're in a paranoid state where they feel like somebody's trying to get them, or bugs are attacking them, or a number of things that they could be having in delusions, then they may be combative to protect themselves or to try to get whatever that delusion is away from them. And so, excuse me, that's situations where direct threat comes into the case, where if an employee is using a mitigative device, which in this case is medication, to control their disability, then they're not going to be viewed as a direct threat. But if you have an employee in that situation that continues to go on and go off their medication, and it creates a safety or hazard issue, and then does meet that definition of direct threat, then you're in a position where you can say to them, we can no longer offer you accommodations for your disability because of this issue. And I've had situations happen where we, attempted to potentially get them into another position within the organization. And if that didn't work, then we had to terminate their employment. So just have to be careful with that direct threat concept. When we look at employers making reasonable accommodations, excuse me, one of the things that we have to discuss and be aware of is what's called the interactive dialogue process. And that's an expression that simply means talking to the employee, talking about the disability, talking about the ways that it affects their activities of daily living, having a dialogue of what the employee views as would be most helpful to them to have them accommodated in their job. And so that interactive dialogue or interactive discussion is basically communication from the employee to the employer about a suggestion that's made, and then the HR department might have to say, all right, let us look into that, see what we can do, run it up the chain. It could be something that requires a modification with equipment or a workstation. Maybe a workstation has to be changed to modify to fit a particular piece of equipment, like a wheelchair as an example, or maybe something has to be moved around. So the reasonable accommodation issue becomes a little difficult because of the undue hardship provision. And so the ADA says, all right, well, if an employee comes to you and they ask you for a reasonable accommodation, you have a right and a responsibility and obligation to consider that accommodation and whether or not it will cause an undue hardship. And where the problems come in is related to the definition of an undue hardship, which basically is completely subjective on behalf of the organization. So I'll give you an example of a case that happened about 10 years ago now. Yeah, I guess it was, because the AAA extension happened in 2008. So a gentleman who was classified as morbidly obese was a forklift operator for this company. He had been there a number of years, great performer, great attendance, nothing with issues with his performance or his employment. He was just significantly overweight. And obesity, morbid obesity, is protected under the ADA if it, again, affects major life activity. And so in his case, what was happening is he had gained more weight over the years that he had been working there, and the seat that was on the forklift kept cracking because of his weight. And so the seat would crack, they would replace the seat, and it would crack again. And when it cracked, it would pinch him. And so he was getting, little mini pinches, and he couldn't put a towel down because it was a forklift. It could get, it was a safety issue. So he did some research, and he went back to his company, and he said, I found a seat that is rated for my weight, and I'd like to request this as a accommodation for my obesity. And they said no. And so he took the case to the EEOC. The EEOC took the case to court, and the company lost, because what he was asking them to spend on this seat did not create an undue hardship for this multi-million-dollar corporation. It was like ridiculous that they weren't willing to spend the money. Yes, was it going to be more money than a regular seat? Yes, but they had already replaced the seat a number of times, and this seat was rated to hold his weight. And so they settled the issue by buying the seat, And, he came back to work and everything was fine. But the company lost the case and they were ordered to, purchase the seat. But that, did not create an undue hardship. Someone that comes and says, I need there to be, thousands and thousands and thousands of dollars spent for this particular issue, the company may be able to defend themselves and say it creates an undue hardship. So that goes back to the question about the 15 employees that we were talking about. A small amount of employees, that company is not going to have a lot of spend available to make an accommodation that to them, $2,000 may be an undue hardship based on the size of the organization. And so then the last part of the ADA is under the hiring piece. And when we look at the hiring piece, this is an area that I know employers, really hiring managers especially, can really struggle with, because not all disabilities are apparent by your eye, right? You can't necessarily look at someone and say that that they have depression, or that they have ADD, or that they have diabetes, even, from a physical perspective. So basically, when you make, when you're going through the application and interview process, an employer, and this is the second paragraph on page 38, really important, may not make pre-employment inquiries about whether or not an employee has a disability on applications, interviews, and backgrounds or reference checks. And so what we are encouraged by the EEOC to do is basically to have any type of requirement on our job description that says what the physical requirements are, what the environmental considerations are. For example, is this a position that requires you to work outside? And maybe the person applying has a medical condition such as lupus that would not allow them to work outside, or would require them to have certain accommodations. And so having those on your job description really helps to have that interactive discussion. Because if you present a job description to someone and say, here's our job description, are you able to perform all the duties in the way that this description is laid out, that gives the employer, the candidate, an opportunity to say yay or nay. Now here's the catch. If they say yes, and then you hire them and they come back and say, well, actually, you have to go through the interactive process. You can't turn around and fire them. And unfortunately, because there is such a serious stigma with employers about hiring people with disabilities, people don't want to disclose it because they don't want to get discriminated against. And they're worried that if they say something on the front end, then they won't get hired. And that's the unfortunate reality of what happens, especially if it's related to hiring managers versus HR departments, because the hiring managers might hear that, I don't want to deal with that, I don't need that headache, I don't want that drama, whatever they say. And then you obviously put yourself in a position where you could potentially have an EEOC claim about disability. But most of the time it comes up, and I'm generalizing, of course, but in my experience, if I look at the number of times where I've had ADA issues before the person was hired and we talked about it versus after, night and day. And I've even had situations where we had a person in a wheelchair apply for a position as a salesperson at one of our dealerships. And when we were interviewing him, we already had ADA access to the building and to the restroom, so that wasn't an issue. But we did have a discussion about the fact that part of the job required being able to drive the cars and being able to be in customers when they were test driving. And so we easily made the accommodation for him by having another salesperson go, if if they were driving the customer somewhere, because the employee, he could ride, that wasn't a problem. He could get in and out, he could transfer from his wheelchair, but he obviously was not able to drive anyone as the driver in the car with a passenger. So everything else was simple, and he was a fantastic employee. And so it's just a matter of having those interactive dialogue discussions. But when you're doing it on the front end, it's a lot more difficult. So we have the responsibility to describe the essential functions of the job and ask the applicant if they can perform them. And if they say yes, then that's what we have to go by. And if they're qualified for the job and we select them and they come back after the fact, then that's something that we have to deal with then from, an ADA interactive discussion. The other piece that comes up on the exams is about medical examinations. So the ADA is very clear that you can only ask for medical examinations excluding drug testing until after an offer of employment has been made. The recommendation is that it is a written offer versus a verbal offer, and written being whether that's email or whatever. Most of us, I think, are in the practice of doing offer letters, but the issue with drug testing, that can be done anytime, pre-employment drug testing. It doesn't have to be after an actual offer has been made. There are companies out there, such as staffing companies, that if you ever go to work for a staffing company, before they even have a position to send you on, they drug test everybody when they come in the door. So pre-employment drug tests can be done at any time, but medical inquiries and requests for medical exams, such as someone who works in a hospital, as an example, can only be done after an offer of employment has been made. And then the last thing really is the issue of known relationships, and this is at the towards the bottom of page 38. So known relationships is disabilities that you're hiring someone, let's say that their child has had cancer, and that's a known relationship, and you know that the relationship exists because they were referred by someone who works for the organization that says, yeah, so-and-so is looking for a job. They've been out of work because their daughter just went through cancer treatments and she's better now. So if you don't hire that person, even though they're qualified for the job, they can turn around and file a claim under the piece of the ADA about known relationships. Because if they are discriminated against because of an issue with someone that has a medical condition, then that would be the same thing like with my daughter. If I were to go out and look for a full-time job, and then someone didn't hire me because my daughter had been ill, then that could potentially be an issue under the ADA. So that's the known relationship clause. And then the last part is just talking about the 1991 Civil Rights Amendment that now makes cases under the ADA have punitive damages and compensatory and liability damages via jury trials. So obviously it has really opened up the amount of money that people can receive on verdicts that are in favor of the complainant. Let's see, Christy said, so I've wondered when it comes to ADA, how can anyone actually prove that they were discriminated against if they weren't hired because it was of their disability? Seems like that would be difficult to prove because the company could just come back and say that they found someone more qualified. And yes, that is a very, very valid observation that you're making, and it is, unfortunately, it is extremely hard So cases, I've actually never dealt with one ahead of time. I've definitely dealt with cases after when the employee was employed with us. But this, I'll give you an example that I did deal with. It was an age claim through the hiring process, hiring practices, and it was actually a claim for a position that reported to me. So that was kind of fun because I was the named one in the complaint. And so I was hiring for a generalist that was going to report to me and was going to work in Orlando. And so when I interviewed this particular woman, she was probably in her 50s. She presented very well on paper. She did well on the phone screening. And so I invited her in for an in-person interview. And part of what I did everything the same with all of my applicants and candidates, is I asked them to do a pre-employment assessment of their skills. And so it was about 4 pages and all kinds of questions. You know, what was covered under Title VII? How would you deal with this scenario? Just, you know, a number of things. And so she filled that out and we had our interview. And then I was looking at, you know, everybody's responses. I had 5 people that I had brought in to interview. And every one of her responses was terrible. And she couldn't even list what was covered under Title VII. And this was someone that had about 30 years of experience at that time. And so I declined her and I hired another candidate who happened to be under 40. And so she filed an EEOC charge against me. And so in my case, even though she knew nothing about what had happened, she was just making the assumption that it was because of her age. And so another candidate, I'm using this example because they could make that same assumption, that it was because they had a discussion about disability. And so in my case, I was able to present all of the reports, all of the documents, all of my interview notes, her actual assessment, the assessment of the other 5 people that I face-to-face interviewed and did the same thing with. And so when I presented all my evidence to say, look, this is what she wrote, it didn't have anything to do with her age. It had to do with her performance in the interviews. And so the case was dismissed. And so that would be what the same thing that an employer would have to be able to prove, that they had these discussions. This is what was discussed. This what, you know, wasn't discussed. And so it's going to be based on the employer's response and position statement and what evidence that they can provide to say, this is why I selected this particular candidate over the one who's making the complaint. And that's going to be, the employee is going to have that burden of proof to be able to prove that. So when, you know, we ask our managers to be able to provide reasons why someone isn't selected, you know, it's frustrating sometimes where they say, well, I just like the other one better. Okay, well, I need more than that, because that's not going to fly if we get an EEOC charge. You know, what specifically was it that you felt like would make them a better candidate? And then, you know, of course you get the, well, it's just a gut feeling I have. Well, I can't respond to the EEOC with gut feeling. So you're going to have to be more specific than that. So that's just an example of same issue, but what the company can prove. You're welcome. Let's see. Cara mentioned, couldn't I just say I have other candidates I'm interviewing? You could, and I think that's probably what the majority of employers do, quite frankly. The challenge is just going to be then in, you know, the timing, because if a candidate does go and files a complaint, again, you're going to have to be able to prove in the end, ultimately, you are interviewing other people. Let's say that's what you told the candidate. but then when you pull the reports, all the timestamps and date stamps indicate that you didn't interview anyone else after you interviewed that person, as an example. And so now you've just shot your reason hole in it, if you will. So you just have to be really careful of what you say and how you say it and when you say it, what stage you say it. The other thing too is if you generally give your candidates a call and let them know they weren't selected, you know, you have to make sure that you're consistent in that. So not that I think that this is a great idea, but there's this trend out there, which I hate, completely hate it, about not even getting back to people when people interview for a position. And so, you know, that they actually go out, they come to the company, and then they don't even take the time to, you know, get back to the people that came in. So anyway, there is one knowledge check question left, but I'm going to tap that on to the beginning of our next section because we're way over time. So any other questions on that? Everybody else, if you want to jump off, thanks if you were able to stick with us. I know not everybody was able to do so, but we can talk about other things if you want. If not, we will see you Monday. So I'll hang out just for a few minutes to see if anybody else has any questions. Maureen, so we're going to finish the rest of this section. Then, as I mentioned before, section 2.2 and 2.3. So it's 51, no, that's not right. Yeah, 51 through 86. Thank you, Lori. Yeah, 51 through 86. Yeah, of course. All right, guys. Thanks for hanging with me. This is always a good topic. It's definitely something that's complex, and we just really just scratched the surface of it. So everybody have a great night and a good weekend. Work on your HRCP, and we'll see you on Monday. Take care, everybody.